Then let's get started. Today, now we have a panel again on transfers, and we try to offer a very practical perspective. We talked a bit in advance, and our aim for this panel is also that we have a lot of room for discussion with the audience. So we will have a round where every one of our panelists will make approximately 7-minute statement, and then we should have a lot of time to discuss with all of you all the challenges that we see with data transfers. Before we get started, I just want to thank all my panelists for being here, and I will introduce them before they get the word. First up, we have Aaron Cooper, who is Vice President for Global Policy at BSA, the Software Alliance, and he's going to give us a global introduction to the theme and also a report from his own practical experience. Please, Aaron, go ahead.
Thank you very much. Thank you for having me, for having BSA as part of this. Data transfers are crucial to what our industry does, and our industry is the enterprise software industry that is creating tools like cloud computing, like data analytics, artificial intelligence, cybersecurity tools that are necessary for the digital transformation of every industry sector to become successful. Digital transformation is not just about automating processes, but it is about using data in new ways. So using industrial IoT to make sure that products are more safe and reliable, using smart technologies in order to do advanced threat analysis, cybersecurity analysis, and prevention, to do digital twin modeling so that manufacturing can be more efficient and effective, and replacement parts can be made more quickly. So digital transformation is having an impact across every different sector, and as a result, because all of these tools rely on data transfers are no longer really just an issue for the tech sector. It's really an issue that affects every different sector of the economy. One of the things that we've done at BSA is create what we call the Global Data Alliance, which is a group of 20, 30 companies outside of the tech sector that have all gotten together to work on data localization and data flows issues, because being able to transfer data in a responsible way is crucial for all the digital transformation success stories to happen. Like one of my co-panelists, we were involved in the Schrems II litigation as an amicus, and I think one of the things that the key thing that we argued was that the use of standard contractual clauses as an alternative transfer tool is crucial in order to enable companies to be able to continue to provide the services that customers and consumers expect from the EU around the world while respecting EU law. But fundamentally, what the case is about was government access policies rather than commercial aspect policies. But we need to work on both of these to make sure that the way companies are acting is responsible, and the way governments have agreed is acceptable amounts of balance between surveillance and data subject rights is also crucial. So I just want to offer one optimistic perspective as we go down the line about where we are on data transfers and what I hope the future will hold. One is a practical matter. As a result of the Schrems II case, we've had DPAs understandably having different views about what kinds of transfers are still permitted, what kinds of additional safeguards are appropriate. That makes sense because that's what the ECJ said was you have to look at everything on a case-by-case basis, but that does cause real business friction, and it also makes it harder for customers to know what they can and can't do. I think the cause for optimism is we've seen the elevation of these issues go from conferences that are focused on privacy to the President of the United States and the President of the European Commission getting together and saying publicly, we're going to have an agreement on what the next privacy shield is going to look like to make sure that, again, not only do companies act properly with data, but that we have a common view again about what government access looks like. And we're seeing similar, I think, move towards convergence in other parts of the world as well. I think with the UK, talking about how to have simplified standard contractual clauses for different kinds of transfers. They'll work on CBPRs. Brazil has a similar kind of addendum to their standard contractual clauses that they're proposing. I think we see a lot of movement towards an understanding that we need to have convergence on how data can be transferred responsibly so that other industry sectors can take advantage of the digital tools that are now available to make sure that they're competitive. So look forward to talking more about it, and thank you very much.
Thank you very much, Aaron, for this introduction into the issues that we're going to talk about. We're now going to move to the very practical level with Christian from Squarebed and Box, where he's a senior associate, who's going to give us an introduction in the practical issues that he sees from his practical experience, and I think that will be a very interesting contribution. I think you have slides, right?
Yes, I do.
All right.
There we go. Excellent. So I'm a private practice lawyer. Our team works with organisations operating all over the world, facing a range of different data protection and privacy issues, including international transfers. So hopefully I can give you a bit of a whistle-stop tour of some of the issues that we're seeing, solutions that are being created, and also some items that are up and coming for the future. So challenges. Let's talk about individuals first. So what we tend to see is a tension between ability and awareness. Generally speaking, people do seem to be more aware of their rights under data protection laws, including in relation to international transfers. We do have a couple of big cases ongoing at the moment. There's one against TikTok. There's another against DeepMind, Google, obviously involving international transfers. There was a big outcry in the UK about consolidation of GP medical data, in particular around transfers to the US. And so we do see some consumer activism, but actually the majority of data subject claims that we see coming through, they don't touch on the international component. They tend to be based on something else. So if that's the case, why is that the case? Enforcement. I think enforcement varies so much between different supervisory authorities. We've seen some of the European authorities be a lot more proactive in this space. So, whether it's the Bavarian DPA going after MailChimp, or the Austrian DPA talking about Google Analytics, the ICO in the UK has not been active in this space at all. Does that embolden organisations? Does it prevent individuals from thinking that they're supported in pursuing these claims? Potentially. Class action claims, there was a big case, Lloyd versus Google. It looked like we were going to have an opt-out class action ability. Looked really promising for a while, but actually there's been some real judicial pushback on that. So what we're seeing is that you have to prove your loss. You can't just claim distress. You're going to have to back that up with something. So again, making those claims a little bit more difficult to bring. And then the third-party beneficiary right, obviously that's how the SCCs work, that's how the UK RDTA works. It's premised on this ability for data subjects to bring this third-party beneficiary claim. We don't see this being utilised in practice really at all. And it's going to be interesting to see whether we see the ADR mechanism in the new UK IDTA being used. That was only a voluntary insertion for the SCCs, and actually we're seeing very, very few, if any, organisations include that within the agreements they're concluding. So challenges for organisations, we've got adequacy. Feels like, certainly for the UK, the sort of Damocles hanging above us. Adequacy decisions, they only last for a certain period of time. They are revocable as well. But some of you might have seen the comments from Foreign Secretary Liz Truss about the Northern Ireland Protocol, whether that endangers the UK's adequacy position vis-à-vis the EU. Potentially it does. We'll have to see what happens. TRAs, obviously as a result of the Schrems decision, we've now got this transfer risk assessment component. A lot of organisations struggling to implement that. It's not as straightforward as what you might think. You're looking at potentially multiple jurisdictions, different legal frameworks, especially for smaller organisations. They're really going to struggle with that in practice, and you potentially end up with this kind of pass the parcel where it's just standardised information that's being passed back and forth. The repapering exercise, this feels like a perennial challenge, been going on for quite a while now. It might have been the case that you had Privacy Shield, old style SCCs, you're now having to remediate all of those contracts. Are you bringing in new SCCs, the new modules? If so, which ones? Do you need a UK addendum? Do you need a Swiss addendum? So a lot of work going on with remediating contracts and getting houses in order. And then SMEs, as I say, I think there's a risk, particularly the UK, that we're going to end up with this compliance gap where smaller businesses, they don't have the means, the capability, the internal resourcing to be able to actually deal with these different aspects. They don't have the funds to be able to bring in external legal counsel all the time at will. So really, really challenging for SMEs in particular. What are we seeing in terms of solutions? So data localization, a lot of service providers now will offer this, usually an additional fee. So we're seeing some clients go for that, but question whether that's actually effective in reality. If it's a managed service or if there's some sort of support element, it might be the case that actually the data isn't going to be exclusively stored in that one jurisdiction, even if you do pay for it. TRA questionnaires, this has become a really common thing. But again, it's very difficult to create a questionnaire that's a one-size-fits-all, covers all transfers. So that's something that we're seeing organizations grapple with, trying to create a solution, but not straightforward as what it might be. Hybrid contracting, I think the majority of larger organizations, if they've got operations in the EU, doesn't really make sense to use the UK IDTA. Even if you're in the UK and you're looking to expand into the EU, I think most bigger organizations, they're going to opt for this hybrid contracting model. So you've got the EU modules with the UK addendum, much fewer organizations opting to use the actual IDTA. So I think that hybrid contracting model is going to be more prevalent generally. And incorporation by reference. The reality of this is that if you add in all these different modules plus the addendum, you end up with a really lengthy agreement. It's not commercially workable. And so what we're seeing a lot of clients try to do is to incorporate by reference, right? And so actually then you're trying to populate these documents by reference as well. Question whether that's good for contractual transparency, question whether that's what the regulators actually had in mind, because it feels to me as though potentially it's not. So incorporation by reference, it's always been around to some extent. I think it's been more prevalent in the States for some time, but we're now seeing that appear much more in the UK space as well. The future, so what we've got to look forward to. In the UK, we've got a new, relatively new international data transfer expert council. So the UK government eyeing 80 billion estimated data-enabled service exports. Part of the council, it's a multidisciplinary team, I think with 20 members, looking at how they can improve on that. And the UK government seems to think that they can generate an additional 28 billion of UK GDP from safe and secure international data flows. We've got the UK Data Protection Bill, so we haven't got too much in the way of detail for this yet, but certainly based on the draft summary that was outlined in the Queen's speech, we know that data flows are a part of this, and we'll have to wait and see what comes from the government in due course. Obviously, this links back to what I was just saying about adequacy. If we change the UK GDPR and we depart from that existing model, how is that going to leave us with the EU? Are we still going to be adequate? We'll have to see. Transatlantic data privacy framework. I'm not going to say too much about this because I know my colleague here is going to speak about it in more detail, but it looks like we're maybe going to have a successor to Privacy Shield. Something to look forward to, maybe. Finally, better guidance, better compliance. I think the ICO has gotten this wrong a couple of times. Ultimately, if you want organizations to use the tools that are available, you want them to do it well, you want them to do it properly, you want them to comply, you're going to have to give them some guidance. And I think it's a period of months now since we had the new transfer tools come out of the UK. No formal guidance to come along with that. So a lot of organizations, people in in-house legal teams kind of scratching their heads thinking, great, we've got these new tools, how do we actually use them? So I think certainly from a UK perspective, it'd be good to have some extra guidance. So who's up next?
All right. Thank you so much, Christian. That was an excellent overview. Next up, we have Eduardo Usteran from Hogan Lovells, where he's the co-head of privacy and cybersecurity, and who has a lot of experience in the GDPR. He promised a very candid overview of the practical issues, so I'm very much looking forward to this. Please, Eduardo, go ahead.
Thank you very much. I'm always candid, and I thought that this would be a good opportunity to share with all of you what I have seen and what my team has seen over the past almost 2 years now since the Schrems II decision. And so let me share with you a little bit, very, very briefly, what I'm seeing. First of all, I know there is a lot of debate about data localization, and Max was asking a question just a little bit in the previous panel. Let me tell you, it's a myth. Communications are global. Information is global. Data is global. We've gone past the stage where you could try to put everything in one box. And I was, in response to someone yesterday, I said, data localization is like trying to get all the water in the ocean and put it into a box. It's just not achievable. So that is a fact. Another fact is that every country in the world has data access laws. Every government in the world is enabled by its own laws to have access to information. It's not the US, it's not just China, it's everywhere. We've done, on our team, we've done, I don't know how many, 30 or 40 different assessments of all these countries around the world. And invariably, all the countries have these powers, and some of them have some controls, others less so. And when you put that through the filter of the essential guarantees that the EDPB talks about, you will find that every single country fails to meet those essential guarantees. So that's another fact. On a more positive note, but this may be even more controversial than anything I've said before, TIAs or TRAs, as you call them as well, they are not too difficult. They're not, I wouldn't say they're easy, nothing is easy, but they're not too difficult. And the reason for that is that I'm already telling you that there are data access laws all over the world. What the TIAs should be focusing on is not the powers that governments have, it's what you do about it. That's what the TIA, if you read the Schrems decision, the focus is how you overcome those powers that already exist. And therefore, you're looking at the measures that you have in place. You should know what measures you have in place, what contracts you have, what policies you have. And therefore, it is an inward-looking assessment as to whether the data is truly protected. So that's where TIAs are coming from. But we have a very, very powerful tool now. And one of the best things that has happened in data protection or European data protection law in recent years is the new set of standard contractual clauses. And you would say, well, a lawyer would say that a contract is a good thing. It is a good thing. And if you read it, it is a very, as I'm saying that, it's a very powerful tool. And if you read clauses 14 and 15 of the SEC, you will see the things that you have to do as an exporter of data, as an importer of data, to protect the data against government access and to limit the chances of that access being disproportionate. So as a tool, they are very, very effective. But on the other hand, what is proven challenging, and again, I've witnessed this over the past couple of years, is these additional safeguards or additional measures. They are tricky because beyond what you would need to do to comply with the model clauses, there is very little else that can actually be deployed. Technology is not going to save us. Total encryption of data means not making the data available sufficiently or widely enough. And if you read again, the EDPB recommendations on precisely these additional safeguards, I'm afraid that many of them are not achievable in practice. At least that's my experience. So all these things are the things that I've been observing. But they all lead to one conclusion. The reality is that the data, despite Schrems II, has continued to flow. I have yet to see an organization, at least any of the organizations I've worked with, that has decided to stop data transfers. What they have decided is to look at how to protect the data more effectively, not how to stop the transfers from happening. And I think, if anything, looking at the glass half full of this situation, what Schrems II is all about is a reminder that when data flows globally, the focus should not be on figuring out what the alternative is to letting the data flow. The focus should be on how to protect the data wherever it is in the world. Thank you.
Thank you, Eduardo. That were powerful last words. Next up, we have Alan Butler, who is Executive Director at the Electronic Privacy Information Center, EPIC, a very nice abbreviation. And he's going to tell us a bit about the US perspective, which is very interesting these days because we have this Transatlantic Data Privacy Framework coming up. So please, Alan, go ahead.
Is this on? Thank you, and it's great to be here and on this panel. I wanted to provide a bit of perspective from the civil society side, specifically in the US, looking back at where we are since the Schrems II decision and thinking about some of those the potential for stronger essential safeguards and remedies, getting to the heart of the substantive issues raised in the Court of Justice and discussed there. We certainly, I think broadly in civil society and certainly in the US side, really saw that the Schrems II decision as an opportunity to push the US to be better, certainly, and I hope more broadly, globally, for civil society to push all governments to be better on, again, the substance of these fundamental rights. And with the news of the US president and the EU president coming to agreement of terms of a framework, it's interesting to think about what is possible, what we might see, what changes we might see, and whether they match up to what both the Court of Justice has said and what the EDPB and others have said about those essential guarantees. We know that the proposed framework will have new safeguards, specifically, targeted using the language, keying into the language of necessity and proportionality, as well as create a new remedial mechanism. And the $1 billion question will be whether those are seen as sufficient, right? So we think about where things are in the U.S. We've reached a point where there's executive negotiation, direct, ongoing, as there has been for decades with the EU, but no buy-in really that we've seen in the legislative branch, right? So getting legal change in the US has been on foreign intelligence surveillance has been incredibly difficult, and even despite increasing motivations internally within the US to achieve change has since so far been unattainable. But we do have on the horizon actually the sunset of the FISA 702 authorities next year. And so while this negotiation over the framework and the development of an executive order is underway, simultaneously things will start to ramp up in Congress in terms of debating what might be put on the table as FISA sunset comes up. But what we saw in 2020 was that when the Section 215, the call data record authorities were set to expire, there was, as I said, bipartisan motivation in the U.S. to sort of correct, I think, some fundamental flaws in that system, and there were even many, very interesting and good proposals, but ultimately there was not enough agreement, a meeting of the minds in Congress, and that they just let that authority lapse. So Congress has not been able to address these issues in a meaningful way, and the dynamics in the U.S. Congress are such that if they are to address these issues in a meaningful way, their likely focus would be on the rights of US persons, not the rights of non-US persons, which is the heart of the problem, right? So when EPIC participated, along with some of our other panelists here, in the amicus phase in the Irish High Court and CJU and Schrems, our focus was on really digging into, the fundamental problem with essential safeguards in US law from the European perspective, which is that US surveillance law fundamentally discriminates between US and non-US persons and enables essentially suspicionless surveillance of non-US persons, right? So that's the core fundamental lack of safeguard, and we have to see whether an executive order can solve that problem, right? Can actually provide meaningful substantive rights, because a lot of focus has been given to the remedial mechanisms, whether they can be, whether essentially the establishment of a data protection court, let's say, within the Department of Justice or authorized by the Department of Justice, can satisfy the legal and remedial basis. But whether or not it can, there have to be substantive protections for it to enforce, right? Because if there's a remedy with no right, then it provides no useful addition, right? And I think that what the prior panel and the discussion on this panel so far, I think, has shown is that there's obviously substantial global interest in this issue, and everyone, I think, the data controllers and data processors out there in the world are kind of along for the ride here, right? Because ultimately, to Eduardo's point, they don't have control over what these governments are going to do. It's up to the governments to establish the necessary safeguards, right? And it's up to the governments to provide the necessary legal protections and remedial mechanisms. And there's challenges, real challenges in US law. One last point I'll make is that, in addition to currently a lack of substantive safeguards, real scope limitations on the scope of collection, for example. They mention legitimate national security interests. So that's narrowing from foreign intelligence, which is incredibly broad, but it's not as narrow, I think, as the EDPS guidance. The idea of creating a truly independent remedial mechanism within the US executive branch is really, I think, a legally difficult proposition given the developments in the US Supreme Court in the last few years that have been a significant pushback on independence within the executive branch and a real push towards what's called the unitary executive view. So I think that there's real difficulties establishing these safeguards in the US, but it's incredibly important, and I hope that we'll see progress as a result of what is a really significant forcing mechanism from the outside.
Thank you, Ellen. That was a very good reminder of what problems we're actually facing in the US with having transfers to that destination. This leads me to our last panelist, Alyssa Vackermans from the European Commission, where she works in the international data flow teams, and she's also involved in negotiating this new framework that we might get soon, hopefully not too soon, for the US. Please, Alyssa, you have the floor.
Thank you very much, and I hope everyone can hear me. It's very nice to be here. Several speakers have already mentioned all the topics that I wanted to cover, so I will just add a bit the perspective of the European Commission and what we are doing to facilitate and to make sure that transfers can take place safely and freely. So the SECs were already mentioned a few times, and thank you, Eduardo, for your very nice comments on the importance of the SECs. I mean, indeed, we know that the SECs are actually the tool that is used the most by European companies. I think there are certain figures saying that it's about 90% of the transfers outside of Europe are based on SECs. So, of course, for us, it was very much a priority to modernize them and to make sure that they were fully aligned with the GDPR, that they are also better adapted to the modern digital economy. And then, of course, after the Schrems II judgment, what we wanted to do is make sure that the clarification, the additional explanations that the court provided, that those were also incorporated in the new SECs. And what we really wanted to do is provide companies with a methodology, with a toolbox that they can use to help them comply with the judgment. So, for example, by already incorporating some of the factors that can be taken into account in a transfer impact assessment, or by already having certain contractual safeguards on how to deal with government access requests. And in doing so, we were working very closely with the EDPB because they were at the same time finalizing their recommendations on the Schrems II judgment. And of course, we wanted to make sure that we didn't go into different directions. And I think in the end, we managed to achieve that. I think you can see that the SECs, the approach in the SECs and the approach in the recommendations are very complementary. And of course, the SECs provide sort of a standardized approach, but one always has to still comply with the recommendations that then go into much more detail into the different steps that have to be taken. And in the work on this modernization of the SECs, we worked a lot with stakeholders because, of course, we wanted to make sure that there's a tool that is practical, that can actually be used. And we want to continue doing this. So once the SECs were adopted, we started working on a guidance document to explain how the new SECs should be used and sort of answer the most common questions on implementation. So in the last months, we've been collecting a lot of feedback from all kinds of stakeholders, from companies, civil society, academia, and so on. And we've now, actually today, we've published this guidance. We've been announcing this for a while, but today it's actually been put on our website. You will see that it answers some very general questions, like what are the SECs, for which scenarios can they be used, when can they not be used, how do I know which module is the right one, how do I implement the SECs into my broader commercial contract. And then there's also some very specific questions. For example, can there be a limitation on the liability, what rights are there for individuals, how can they exercise them, and so on. So as I said, this has been put on our website now, and I would invite all of you to have a look. And of course, let us know if there's still things you think that are unclear or that we have to clarify further, because the idea is really that this is a sort of a living document that we continue to update as there are new questions. Then another interesting development I wanted to mention, this is the last point on the SECs, and it has already been touched upon a bit. What we've seen in the last years, and we find this very interesting, is that there are more and more other countries and regions around the world that are adopting very similar tools. So the UK and Switzerland have already been mentioned. They essentially took the European SECs and adapted them to their own legal frameworks. But there are also a lot of other countries like Argentina, New Zealand that have developed their own model clauses that have a lot of similarities with the EU SECs. And also we've seen in Latin America and in Asia very interesting regional developments. And I can imagine that for companies this sometimes may look a bit daunting to have all these different types of clauses, but from our perspective, looking at the substance of these clauses and the fact that they have a lot of things in common, we think that also provides further opportunities to work and to see how they're then implemented in practice and whether there's room for further convergence also in the implementation of these different tools. Then moving to another topic, to the US, because I know that everyone always wants to hear an update on that. But actually, since the announcement in March, where there was an announcement that the EU and the US have reached an agreement in principle on a new framework, since then, a lot of work has actually continued at technical level. So what's happening now, since there is this agreement on the main elements of a new framework, all of this, of course, still needs to be translated into concrete legal texts. So the United States government, they're currently working on drafts of a new executive order, as was already mentioned, and different implementing regulations. And we will then, of course, look together with the US at these drafts to make sure that they fully reflect everything that we have agreed and that we have a solid basis for to propose an adequacy decision. And then, as I'm sure you know, then to adopt an adequacy decision, we still have to go through different steps. We first have to obtain an opinion from the EDPB. We need to obtain the green light from the member states. And all of this takes place also under the scrutiny of the European Parliament, who we know has a very big interest in these topics. And I know everyone is wondering about the timing. As you can imagine, it's very difficult to give a clear timeline on this because it depends on how soon we will receive the drafts from the US, but then also how long it takes to go through all these different procedural steps. But from our previous experience, if everything goes well, usually it takes about 6 months from the moment that we propose a draft decision to its final adoption. So at the very earliest, I would say that will bring us at the end of this year, the beginning of next year, but we will have to see how everything goes. Of course, Yeah, a last point I wanted to mention, and then perhaps I will stop already so that we can go to the questions, because I think this will be of interest to the audience, is that everything that we have negotiated with the US, or that we're still negotiating, which of course focuses on national security aspects. So on the one hand, how the US intelligence agencies, how, under which conditions, in which circumstances they can collect data for national security purposes, and then also how individuals can obtain redress. All of the safeguards that we are negotiating with the US, they will be part of the new framework, but they will also apply across the board. So companies using SCCs, BCRs, any other transfer tool, all of these safeguards will apply for those tools as well. And that will, of course, have a big impact on transfer impact assessments, for example, when it comes to data transfers to the US, because all of these safeguards will be something that can then also be taken into account. And I think I will stop here so we can have a discussion. Thank you.
All right, thank you, Alyssa. I already made a reading list now, what I have to read as soon as this panel is over. Thank you for all panelists. I think we have set the debate very nicely. I now want to open the floor to the audience because I think practical issues is something that is best discussed all together. Are there any questions already? Well, then I will ask the first one, and you think about yours, but I'm counting on you. So I think for me, my first question would be, I mean, we've heard that transfers, it's not going to be possible to not have transfers. We need them also. On the other hand, it's about protecting fundamental rights, which especially Ellen has mentioned. So what is the key to finding the balance there, like transferring and protecting fundamental rights? What would you see as the key for trying to find a balance there? You want to start, Aaron?
Yes, thank you. So I love that line at the end of Eduardo's presentation, and I think it is what I would say is the bright spot of the Schrems II decision was that it didn't say no more data transfers and you have to try to do data localization, which, as Eduardo points out, is not really a practical solution. But instead, it said you have to think about what the additional safeguards are, many of which are now incorporated in the new SECs, that will make sure that the data is protected wherever it goes. So I think one of the things, among many things that DG Justice has done really well, is to both push back against data localization rules around the world, and try to put the focus on, is the data that's being transferred going to be protected wherever it is going to be transferred? And I think that's the key for people to focus on.
Thank you. Eduardo, maybe you want to go next?
Yeah, I think if we take a step back, and I think perspective is really important in thinking about it, because we're so focused on all these things, you know, transfer impact assessments and SEC and all that. We're trying to address, which is essentially a conflict of laws. You have more and more laws around the world. Europe has had this since the mid-90s, but more and more, setting out frameworks that are aimed at ensuring that our personal information is protected wherever it is in the world. And the whole premise behind limiting data transfers in the EU has always been, we don't want to create a fortress Europe for the data, and then the data flows elsewhere and that protection is lost. So we want to extend the protection. So that's one side of the equation. The other side of the equation, of course, is that, again, as I was saying, every single country around the world gives, by law, their own governments the powers to do a number of things, including having access to information for law enforcement, for intelligence service, and all kinds of functions of government. And therefore, there is a conflict in the context of government access to data between the aim to ensure that the data is protected according with European standards or the standards of whichever country in the world we're talking about that is supporting the data, and the access to that data within the destination country. And it is a conflict that is never going to go away. So the new privacy shield will be adopted, and it will always be work in progress. I don't know if you guys appreciate this. We're not going to get to the point where in December 2022 we're going to resolve this. it will never be fully, because it's a conflict that is permanent, and therefore you try to resolve it. And you guys are trying to convince the US government to be more democratic and more considerate about individuals and so on. And Max is trying to put a lot of pressure to ensure that companies within the US, for example, force their own government to take action and so on. So that's a lot of efforts that goes there. Lawyers like me, we're saying to our clients, you guys need to ensure that whatever you do, you have a strong argument to say to whichever regulator or whichever privacy activist is challenging you that you've done everything that is possible and is effective enough to protect the data. But that's a conflict that will always exist. You see what I mean? And therefore, if you work in this area, you're never going to be out of work because you will always have a role to play.
That's good to know. Very reassuring. Ellen, you want to add something?
Yeah, I agree with Eduardo that this is going to be an ongoing conflict, and it is a conflict of laws, but it is really, again, at its core, a conflict between fundamental rights and laws and legal authorities. And this is an iterative process of trying to improve globally the legal authorities that conflict, that butt up against fundamental rights. And my hope is that through this iterative process, the U.S. can improve its protections and can, through its framework and through subsequent challenges and subsequent iteration, can push other countries to improve their legal standards as well, right? One of the criticisms I think that's fair that the U.S. has lobbied in the past is to say, well, core competencies, what about member states in the EU? And we should have that conversation, and as we do in the U.S., and there should be a push to standardize, right, to create a global baseline fundamental rights standard with respect, in this particular context, to national security access to personal information, because there shouldn't be bulk national security access to personal information, right? There shouldn't be national security unfettered access without individual remedies, right, or individual safeguards. That's the whole point of all of this, is that shouldn't exist. And again, I recognize that no individual company can control that, right? To Eduardo's point, companies can encrypt data, but if you're going to use that data in a jurisdiction, you have to decrypt it at some point, and it's going to be potentially subject to national laws, right? So it's all about pushing, motivating the lawmakers and the executive branches in different countries to make real meaningful changes to progress fundamental rights. And we've seen that happen in other contexts, right? I mean, in the US, when Microsoft challenged extraterritorial data access and it went up to the US Supreme Court, Congress stepped up and actually passed the Cloud Act. We have not seen that happen with post-Schrems international data transfers, although we see executive action. So I think, again, we are just going to continue, certainly we in civil society are going to continue to push, and I'm sure as civil society will in Europe, and we hope that the companies that are subject to this level of scrutiny as a result of these transfers will push as well, because the reality is that there are massive sort of economic benefits of a global data system, but there are massive potential costs to fundamental rights, and that's why we are having this debate. That's why we are pushing through this iterative process.
Thank you. Christian and Alyssa. Alyssa, maybe first, do you want to add something?
Yes, thank you. No, maybe just to say first on data localization, I think indeed we've seen this lately, partly as a reaction to the Schrems II judgment, that some companies make the commercial decision to keep data in Europe, but I think the Commission has always been very clear on this, that this is not something that we want to I don't know, that we promote or that we see as a policy. We indeed, I think we fully recognize the importance of data flows and the importance of making sure that that data can continue to travel across the world with a high level of protection. I do agree that, in the end, when it comes to questions like government access, it's true that companies can only do so much. In the end, this is a question that has to be resolved between governments. The interesting thing is that, now in Europe, we often talk about this from a Schrems II perspective, a European perspective, but in the last years we've really seen the same type of discussion happening across the world in different countries at national level, but also at international level, there are now more and more initiatives to try to indeed develop this type of what could be global standards when it comes to questions like how national security authorities can obtain access, what should be the appropriate limitations and safeguards that apply in this context. For example, there's very interesting work ongoing in the OECD, and I think that has been a very interesting and promising development, because that's indeed, if we can come together with like-minded countries to think at least about how we think this type of questions of government access should be framed, that's perhaps something that can also help all of us in the long run, and including especially for fundamental rights. So,
thank you. Christian, you have the last word.
Sure. So, I mean, I think there's always going to be this tension, right, between free movement of data, safeguards, how do you safeguard individual rights, and I think different jurisdictions, different administrations will treat that differently. So I'm not sure there's kind of a one-size-fits-all panacea for that can be applied across the globe. Certainly from a UK perspective, what we're seeing is that discussions around adequacy, new adequacy decisions, that's been bundled in with trade discussions as well. So, those jurisdictions that have been kind of highlighted as potentially adequate jurisdictions in the future, these are also countries that are being eyed for trade deals, right? So whether it's the US, Australia, India, Indonesia, these are all countries that the current administration is looking at for kind of post-Brexit dividends potentially. We're going to strike a trade deal, adequacy will be a component of that trade deal. And so, to the extent arrangements like that result, I think, you've got to accept that to some degree, yes, you've got to think about individual rights, but there are also political, economic drivers behind these decisions, and and that impacts on which jurisdictions are going to be first in line to have those conversations. So I think that's also worth bearing in mind.
Yes, indeed, the trade perspective is an interesting one. Now the audience had a few more moments to think of questions. Please, yes, there is one up there and then another one up there. Here, I think, yeah.
Hi, Kevin McGillivray from the Norwegian Tax Administration. My question is mostly for EPIC. What can we expect between an executive order that wasn't provided in Presidential Policy Directive 28? So we had some protections that were put into the Presidential Policy Directive, like the categories of data that could be collected. It seemed like there was some push for more rights for European citizens. But what really needs to be different for this to be a durable solution?
Sure, I think that, I think the EDPB guidance is certainly helpful in thinking through what that assessment is going to look like. I think that I mentioned before scope limitation. So one of the major problems with 702 as it exists, and Executive Order 12333 as the key legal U.S. foreign surveillance authorities, is that they're keyed to this definition of foreign intelligence information that is incredibly broad. I mean, when you read it and you understand what it means, it essentially, there's almost nothing that doesn't fit in the category of foreign intelligence information from the U.S. perspective. The phrase that's used in the fact sheet that was issued in connection with the statement by joint statement was essentially national security information, which still I don't think is, we haven't seen the final text, but even that is narrower, but I don't think it aligns with the guidance. So it needs to be really specific and focused, purpose for the collection. I think the question about whether there will be, what the review will look like and what basis there will be to review targeting decisions will be a major component, and what can be, some of the arguments made by the U.S. in the past were essentially that under the programmatic surveillance under 702, ultimately there are targeting decisions that are in many cases individualized, was essentially what they argued. But because that's not enshrined in the law, there's no legal limitation to the targeting, right? The targeting procedures get designed and essentially sent to the FISA court, and they look at them and they say, this is a targeting decision. They don't, because there's no fundamental right, Fourth Amendment privacy right for non-US persons in the US, the FISA court can't say, well, this targeting decision violates the Fourth Amendment, for example, because non-US persons abroad, US courts have said, don't have Fourth Amendment rights. So that's, again, kind of gets to some of the substantive flaws in US law. So I think there have to be real subject matter limitations, both in terms of categories of reasoned basis for targeting data, but also specifying, what the basis for individual targeting decisions will be in the law, as well as providing, real rights that can be remedied through the remedial mechanism, as I said.
Yeah, I think maybe it's best, I saw 3 questions up there. Maybe we can take all of them and then we move forward.
Could I say one thing quickly in response to that? Because I agree a lot with what Alan was saying, particularly about how you can't have a static system of balancing national security and fundamental rights, because we're going to constantly have an evolution of norms of what tools are available, what data is available, and so on. But we shouldn't lose sight of how important what the Commission and the administration did in having a tone that was intended to get to yes and a constructive dialogue. Because the other thing that the U.S. administration could have done at some point is just pull the protections that were in PPD 28, which were a big part of what led to the first privacy shield, to enable the first privacy shield. But because there were these constructive dialogues, it is being built upon now instead, which I think is a really good thing. And it also goes to the point about the OECD, where we're just seeing lots of different places, the G7, where those conversations about what the right balance is, and it needs to continue to be analyzed and changed.
Can I, Laura, just also to briefly add to this and to respond to your question, because of course I cannot give too many details because the negotiations are still ongoing. But what we've been discussing with the US is a new executive order that will set out a new legal framework. So it will have new rules implementing what we call the principles of necessity and proportionality, and this will really apply. So it will go beyond what is currently in PPD 28, and it will set safeguards throughout the whole, let's say, life cycle of national security activities. So when it comes to identifying what are legitimate objectives to collect data, then under which circumstances and which conditions data can be collected, then also the further use or further sharing of data. So all of these elements will be covered by these new rules.
Thank you. Yes, now the 3 questions up there.
Yeah, hi, I'm Naveen. I'm Naveen Jain. I'm from Leiden University. I'm a master's law student there. I have 2 questions. The first question is about proportionality and necessity. What Schrems II judgment, so in terms of proportionality and necessity, my question is that if that is applied, would Schrems II judgment not be violated in a way? Like the proportionality and necessity would just be enough, or we need something more than that? Second question is about the data protection codes that I've heard about that they're planning to introduce there. So in terms of the structure of a court, it's not going to be the same like a court or tribunal. So would that be enough for the enforcement of data subjects' rights in US? These 2 questions. Thank you so much.
Then let's, yeah.
Hi, Carrie Lenning with Castlebridge in Ireland. So the big question that I run into is what I think Odia Kagan has described as we're kind of up a creek. It's just cry and pray now when it comes to dealing with data transfers to the United States in light of the Austrian DPA, French CNIL, and Danish DPA kind of guidance and decisions. And I'm just kind of wondering, outside of encryption, basically they say that any transfers to the United States are basically verboten because it's just always a risk. And since there's no more risk-based approach, it basically means you can't really do transfers to the United States. So I'm just wondering if anyone else here on the panel has thoughts about other technical measures, other ways that we can actually effectuate transfers, because that seems to be the only thing that they're kind of agreeing with anymore, and or if it's just all cry and pray at this point.
Okay, there was not another question there? Okay, then let's tackle those 2, and then we get back to you. Anyone who wants to answer any of those 3 questions? Okay, Alyssa, please.
Yeah, I can go with the first one on the US and on the Schrems II judgment. I think one thing that we have to keep in mind is that compared to when we were negotiating the privacy shield, This time, we actually had a much clearer mandate from the Court of Justice. I think the Schrems II judgment was actually the first time that the court went into the details of what necessity and proportionality means in an adequacy context and what there needs to be in terms of redress, so what is considered to be essentially equivalent to a court as it is seen under the Charter of Fundamental Rights. So for us, that was, of course, the benchmark. That was our mandate for these negotiations. So when it comes to necessity and proportionality, just to be clear, when we use these terms, I know that they're very general. They don't mean that much used like that. And of course, we're not just looking to have these words in the legal framework. It's about going into more details of what necessity and proportionality actually means. For example, in terms of how specific surveillance measures are chosen, how to balance the different interests at stake, the public interest and the interests of individuals and so on. So it goes, of course, into the specifics of what these principles mean in practice. When it comes to the redress here, so indeed, as you mentioned, what's going to be part of the new framework is a new data protection review court. It will be formally within the executive, but the members will be from outside of the US government. It will be external people, and they will benefit from different safeguards to ensure their independence, and they will also have the powers to take binding decisions. And that, of course, is a big improvement compared to what was in place before, where we had an ombudsperson who was really part of the US government and acted more as a mediator, did not have the powers to investigate or to impose binding decisions. So there will be a big improvement compared to what was there before.
Yeah, and I'll just add quickly that the PPD 28, to the point that there wasn't the specific guidance pre-Schrems II. I mean, PPD 28 really did not create, I think, meaningful and sufficient safeguards, even for U.S. persons, let alone non-U.S. persons, and that was, really, I think, much of the reason why the outcome was as it was in Schrems II. And the ombudsperson role, I think, was never really perceived in the U.S. as was never really treated as a serious role and as a serious redress mechanism. I mean, it was a shared position. It was never really heavily staffed. It never really did anything. I think the idea of creating, by regulation, a formal entity I see the potential there. I think it's challenging in the U.S. legal system to have that be really robust, independent separation from the executive, and that I think will be part of the big question following formal text and next steps is how that looks, and again, how the essential safeguards look.
Okay, then anyone else who wants to add, maybe also on other technical measures, how we can, Eduard.
I just wanted to address the point about the the impossibility of getting it right. There is a sense of, you get to a point where you simply cannot lawfully transfer personal data. And I think you have to take that in steps in a way. First it's very, very important that we appreciate that this is not about preventing all types of access to data by government. We're talking about necessity and proportionality in a democratic society as well. So I think you have to make a distinction between which countries you think are democratic or not, and so much focus is on the US, and I think the US is, pretty democratic. I mean, in the sense that if you were trying to do your job in Russia, you wouldn't be here today, you would be in jail. So it's true. So I think that there is an element of that. There's an element of really thinking about we often think about something that is impossible. Don't think about what is impossible. Think about what is possible. A lot of the data flows are to service providers, to vendors. Many of those that are on the the sponsorship list here. Work with those vendors. Those vendors are bending over backwards today to try to show to their European customers that they protect their data. So I think that is a lot of focus on what you can do. And then the final point I would say is it's about also having the right argument. So this is not mathematics. This is not an equation where you add you use a formula and you reach a point where you say, yeah, now it's lawful. Is much more subtle than that and much more nuanced than that. And you have to be able to construe an argument where, again, if a regulator, and there's some unreasonable positions that we're seeing regulators taking, but if a regulator comes to you, you say, thank you for asking the question about how we protect the data. Let me tell you how we do it. And have confidence in your argument.
Thank you. I like your optimistic tones always. I saw a question there. Is there and there? So let's take both of them together. First, Susanna, and then Simon.
Hi, I'm Susanna Gulczynska. I'm doing research at Ghent University about actually international organizations and data protection. But of course, that necessarily involves question about data flows. And I have a question because I got, I think rightly, the impression that you all say that we need to build bridges and have a more common understanding of what we're protecting, where we should go. And I have actually two questions in this relation. First is related to specific aspect of data, surveillance by governments and data access by governments. In the countries of data importers. And I wonder if you think that EU is doing enough to build these bridges. And what I mean more specifically is that, for example, when it comes to the standard of protection, Advocate General in the Schrems case proposed that this standard should be European Court of Human Rights standard and not our local EU standard, which is higher, and this proposition was refused. So essentially, when we have security questions in the EU, these fall outside of the competence of the EU, which means that we mainly apply lower standards than what we expect from our partners. And I wonder, and the second aspect is that also in the Convention 108 Plus, we have these provisions that will be, when they will be applicable, that will essentially the principle is that we allow and we should request this free flow of data, but when we have some local arrangement between ourselves as EU mainly, but also now other countries are building towards that too, we can actually request additional safeguards. And my question here is, does EU do enough to actually build the bridges and create common understanding of what surveillance should be? And I'm going to abuse a little bit the fact that I have microphone and ask a second question, which is not related to surveillance. And we mainly focused on this in this panel. But there's another problem, and I think maybe it's a little bit overlooked and should it be introduced more in international discussions about what we understand under data protection. Because I think it's very different with the US. It's very clear to me that privacy and data protection are not the same terms. And for example, that was exposed very well by High IQ versus LinkedIn case, which was about data harvesting, in which the question of data protection or privacy of users of LinkedIn was not raised at all. And we have a very similar case in still pending in Poland. It's a Busnode case where essentially it was also about data harvesting, and that's the only question that's raised there, whether we should inform individuals, whether they should be allowed to withdraw from, revoke this, or rather oppose to the legitimate interest of the processor. So I see that there's at least in some areas, there's not common understanding as to what it is that we're actually protecting. And without this common understanding, I don't see how we can have free flows, because there's always going to be a problem. So these are essentially these two questions. Thanks.
Thank you.
Simon Ania, DPO at Uber. I have a follow-on question to that one. So Alyssa explained the process we're going through with, there's now going to be more meat at the US side on what necessity and proportionality means. That's going to be put forward as part of the adequate decision, which will be put forward to the member states, which then essentially will require them to approve something which could be used as a benchmark in favor or against them on their own practices. So are we now in a situation, which I would applaud, in which CJEU has thrown a boomerang, propelled by the European Commission, served back via the US government, hitting 27 European governments to improve their own practices in this space? Is that what we're going to see? And if so, to what extent would that threaten the adequate decision to go through smoothly?
Okay, thank you. I think we're at the end of our panel. So maybe we could take one more question if it's a quick one, and then I will give the panelists all the last word to answer to your concerns. I don't see any hands though, then more time for you to answer. Who wants to start? Anyone feels inspired? Maybe Christian, you want to start?
I'll just pick up on this gentleman's last question there. I mean, intelligence gathering, as Eduardo said, all countries do this, and this was raised during the UK adequacy discussions as well. Intelligence gathering by GCHQ, other UK intelligence organisations, that was an issue in the adequacy process. I'm not aware that resulted in any changes on the EU side in terms of how they conduct their own intelligence gathering activities. So, I mean, I agree with you. I would like for that to be the case, and I would like to see improvement across the board, encouraged by that process. But I'm personally not confident that will be the case.
Yeah, thank you. Shall we just go one by one, and Alyssa, you?
Okay, I will try to respond to all the questions in one go. To start with the standard that we have to apply also for an adequacy assessment and what the court said in the Schrems II judgment, I think it's not so easy to make the separation between EU law and the ECHR in this context. Yes, the court said that the standard is the Charter and EU law, but of course there is a body of case law of the Court of Justice and the treaties even saying that the ECHR or general principles of EU law, it's almost part of the EU legal framework, even though we're not formally a party. And I think this is a relevant standard in this context, the ECHR. There's 50 years of case law of the Court of Human Rights in this area of national security that goes into these questions. What is necessity? What is proportionality? What does effective redress mean in this area? So I think we cannot just ignore this and set this aside. I think this is part of the standard. And it also answers, I think, your question. This argument that somehow we're first going towards the US or that we're applying a standard to the US that we're not applying back home, I don't think this is correct. The standard is essentially equivalent, and it has to be equivalent to something, which is what we apply in the EU, and that is based off EU law, constitutional law, the European Convention and human rights. So I don't really agree with this premise. And then on the question of whether the EU is doing enough, I will of course say yes, because that's what my unit is doing. We're engaging on a daily basis with countries, with regional organizations, international organizations at bilateral and multilateral level, not only on general questions of data protection, but also precisely on these questions of government access. We're very active at the level of the G7, the G20, and in the OECD, the Council of Europe. So this is really a very big part of our work and something that we believe in, because indeed sometimes there is a discussion on whether we mean the same things with certain concepts. I think maybe at a superficial level there may be differences in understanding things like the notion of data protection, notions like necessity and proportionality, but at least from my experience, when you look at the practice, at specific legal provisions and how they're applied in democratic countries, very often there's not such a big difference, even in the EU and the US, even though it's sometimes portrayed as a very different approach. I think when it comes down to the specifics, it's often not that different.
Thank you. We're running a bit of time, but 20 seconds each, we can do it, right?
To the third question, yes, I hope it does boomerang. I hope this can have a rising tide effect, but time will tell. To the second question, I just take issue with the fact that privacy was raised because we filed a brief in that case, and also LinkedIn did make some of the arguments. Happy to chat about it, but there's a lot of troubling developments in the US commercial data side, even though there's a lot of good progress as well, but that one in particular concerns me.
My final point is that we should stop seeing legitimizing data transfers as a static process that you go and reach a destination. And adequacy should never be static process. It should be a dynamic process. And in the, for example, the role of, I'm involved in this UK government International Data Transfers Council. And the advice that the UK government is getting from people like me is don't just go and be ambitious about international data transfers, be ambitious about what you are doing with other countries to ensure that fundamental rights are being respected on an ongoing basis.
We should want all like-minded democracies to get together and agree on what are the right government access standards and privacy protections, because it's important for all of us, whether it's because of the adequacy decision or not. It's something that G7 I think is doing really well. OECD is doing, and I'm glad to see we're having more of those conversations now.
Thank you. Then I don't want to keep anyone from lunch. Thank you very much to our panelists. It was a great discussion, and thank you to the audience.